All right, today we're diving into a fascinating Supreme Court of Canada decision that really gets to a crucial question. Where does public road policing end and your private property begin? And trust me, this is a case that has implications for pretty much every driver in the country.
So let me paint a picture for you. You're pulling into your own driveway late at night. A police cruiser has been behind you. Can that officer follow you onto your property to start a random sobriety check? That's the exact real-world question Canada's top court had to grapple with. Okay, so how did this all start? Well, our story begins around 12:30 in the morning with a man named Walker McColman on his ATV. And what started as a pretty ordinary late-night drive home turned into a legal battle that would go all the way to the top. And things happen fast. Police see McColman and decide, while he's still on the public road, that they're going to pull him over for a random sobriety check. But before they can, he turns into a private driveway. And this is the key detail. It's only after he's on private property that the police finally flip on their lights to start the stop. The whole thing, from first sighting to arrest, took just 6 minutes. Now, to be clear, the evidence here was pretty cut and dried. Mr. McColman's breathalyzer test came back at 120, which is well over the legal limit of 80. So factually, he was driving impaired. But that's not actually what this case was about. The real question was about where the stop happened and whether the police had the right to do it there. And this is where we get to the heart of the legal puzzle. You know, it's kind of wild, but this entire massive case, which went all the way to the Supreme Court, basically boiled down to how you define one little word: driver. So check this out. The Highway Traffic Act had two different and kind of conflicting definitions. On the one hand, you've got the general rule. A driver is someone driving on a highway. Location is baked right in. But then you have this other, more specific definition for sobriety stops that just says a driver includes someone with care or control of vehicle. See the problem? It doesn't mention a highway at all. So which one applies? So this became the million-dollar question, right? Does a police officer's power to conduct one of those random stops, where they don't even need a reason, does that power just stop dead at your property line? Can they follow you up your driveway or not? And man, the lower courts were all over the place on this one, which really just shows you how confusing the law was. First, the trial judge says, yep, stop's legit, guilty. But then it goes to an appeal judge who says, nope, unlawful, acquitted. The Court of Appeal agrees. It was a total legal seesaw, which is why it had to land at the Supreme Court's feet for the final word. Okay, so the Supreme Court takes the case, and the very first thing they have to do is sort out that messy driver definition once and for all. And what they did was pretty smart. They essentially harmonized the two definitions into one clear rule. They said, look, for a random sobriety stop, a driver is someone controlling a vehicle on a highway. That location part, they ruled it's absolutely essential. It has to be part of the equation. And once they landed on that definition, the conclusion was inescapable. McColman was on his parents' driveway. He wasn't on a highway. That means, legally speaking, he wasn't a driver anymore, at least not for the purposes of this specific law. So bottom line, the police stop was not authorized. Simple as that. Now, this is a huge deal. An unlawful stop isn't just a technicality. The Supreme Court called it an arbitrary detention, which is a direct violation of Section 9 of Canada's Charter of Rights and Freedoms. So you're probably thinking, okay, game over. Illegal stop, the evidence is toast, McColman walks, right? Well, here's where things get really interesting. This is the big twist in the story. Because, and this is so important, just because police violated someone's charter rights, it doesn't automatically mean that any evidence they found gets thrown out of court. Nope. There's a whole other step, a specific legal test for that. And honestly, this is one of those things a lot of people get wrong about Canadian law. It's really a two-part question. First, was there a charter breach? In this case, yes. But the second, totally separate question is, can we still use the evidence they found during that breach? To answer that second question, courts use something called the Grant test. You can think of it like a set of legal scales. They're trying to figure out if using the illegally obtained evidence would make the justice system look bad, if it would, in legal terms, bring the administration of justice into disrepute. So let's walk through it. First, the court looks at the police conduct. How bad was it? They said, low seriousness. Why? Because the law was a total mess at the time, so the cops weren't acting in bad faith. They were just working in a confusing legal gray area. Okay, second factor, the impact on the accused. The court called this moderate. I mean, being detained in your own driveway is a pretty big deal. But then there's the third factor, society's interest. And this one, they rated high, super high, in fact. The evidence was reliable, and society has a huge interest in prosecuting the very serious crime of impaired driving. So when you put all that on the scales, you've got the police conduct, which was a low concern, the impact on the individual, a medium concern, but then this huge, heavyweight concern of society's interest in trying the case. It's pretty clear which way the balance is going to tip. And so, the final call? The evidence stays. Yup, even with the unlawful stop, even with the charter breach, the court decided to admit the evidence. And just like that, Walker McColman's conviction was put back in place. So what does this all mean for you and me? Well, one of the first things people worried about was this idea of a sanctuary problem. The fear that now impaired drivers could just see a cop car, quickly duck into the nearest driveway, and be totally home free. But the Supreme Court saw that coming. They addressed it head on and basically said, hold on, that whole sanctuary problem is overblown. And the reason why is really important, because it all comes down to two very different types of police powers. And here it is, the crucial difference. This whole case, this entire ruling, is only about random stops, the ones where police have zero suspicion. If an officer actually sees you swerving, speeding, or driving erratically, they have what's called reasonable and probable grounds to stop you. And that power lets them follow you pretty much anywhere, driveway included. So this is definitely not a get-out-of-jail-free card. Not at all. Okay, so let's boil this all down. What are the big takeaways here? 1. For random, suspicionless stops, the police's power now has a clear boundary, your property line. 2. A police mistake, even one that breaches your charter rights, doesn't mean the evidence is automatically tossed out. And 3. This all just shows that the law is this constant, tricky balancing act between our rights as individuals and society's need for safety. And that really leaves us with the big lingering question, doesn't it? We all want to stop impaired driving. It's a terrible crime that ruins lives. But where exactly do we draw the line between giving police the tools they need to do that and protecting our fundamental right to privacy at the edge of our own driveways? This case drew a line in the sand, but it's a line that will probably be debated for a long, long time to come.